in a world not of their making.
Good evening and welcome back to the Human Rights Enigma and part 2 of Children, Divorce, Custody and Human Rights. And welcome back to my distinguished guest, Dr. Puri Quisumbing of the United Nations, and to Joseph Sahid. During our last segment, we discussed an international instrument which Americans and other people have little or no knowledge, and that is the United Nations Convention on the Rights of the Child. Now, so we should return to that, but I think, Doctor, you posed an interesting question to me before we went on air, and that was, should we be interfering, the state or even the international community, in what are domestic relations?
Well, I asked that question, Stuart, because in our discussion we seem to be assuming that it is acceptable for the state to interfere in certain spheres of domestic life, which used to traditionally be considered private area, where the state has no right to interfere or to even regulate, and definitely not to control. And now we have, in fact, expanded this to a question of what areas of domestic relations, domestic meaning family, particularly family relations, can be interfered with by the international community, particularly by the United Nations or other international tribunals. So I think this is something that we need at least to clarify.
Well, is there an argument, Joe? I mean, I'll ask Joe. Is there an argument to be made for the proposition that perhaps the state should not interfere at all? If we are in agreement that it's not getting it right, I mean, and we look at the statistics of divorce, we look at the results of the custodial conflicts, we look at the economic statistics, the crime statistics, and all of the other statistics that are available, which show the result of single-parent family environment, is there an argument to be made that we should get out of the business?
Well, we can't get out of the business. We're in the business. Today we make
lots show business.
we make lots of decisions about what happens with children, and we're not about to stop doing that and sort of turn it over to the law of the jungle or something. And so the question is when, under what circumstances should we intervene? Now, you're right. All of those statistics that you're just talking about indicate a growing problem that's going to come to a head in the next 10, 20, or 30 years as these children today grow up in numbers never before seen.
Yeah, I think Daniel Amnius, the professor at the University of California, has written a marvelous book called The Garbage Generation, in which...
Now, if we're looking at a problem that's growing and is very serious, and if we say the way to deal with that is to do nothing, then that's a mistake. I mean, we have to do something, there's no reason to defer to a particular state or a country because nobody's doing a very good job at this. If there was somebody, some entity, governmental entity, which was doing a good job of dealing with these problems, then we might say, well, leave them alone and let them take care of the problem the way they're taking care of it. The reality is that throughout the United States, at least, I can't speak for the rest of the world, but I know that throughout the United States, we're not doing a very good job at all. The states are doing a lousy job, in large part because the federal government has stayed out of the business.
As domestic relations exception.
And for various reasons and using various words, they have, over the years, not been willing to interject themselves into domestic relations matters, just as up until the 50s, they refused to get involved in matters having to do with education, which is why the United States had a policy in place.
Interesting you say that, because Dean Glickstein, who was one of our previous guests, raised this issue himself, saying that...
Yeah, I mean, we for years we allowed the states and the South particularly to do what they wanted about education, and what they did was they kept blacks out of the public schools. It wasn't until the 50s that the federal courts said, wait a minute, we better do something about this. And well, the same pattern is being repeated in domestic relations. The federal courts have sort of stayed out of it, leaving it to the individual states. And what's happened is that the political agenda in the individual states has taken over and led to a pendulum swing that has gone too far.
Well, I want to stop you there because I've got a host of questions to address to both of you. The first one is because I've reminded myself that I had intended to ask Puri about a discussion we had some weeks ago, in which I believe, and I hope I'm not misquoting you, you suggested that perhaps there was room for an ombudsman, an international ombudsman of children's issues, and I'd like you to explain what that might be.
Well, our discussion was on the basis of not a movement in the United Nations itself. It's a movement from grassroots organizations, and there are several non-governmental organizations who are interested in children's rights that feel that the Convention on the Rights of the Child will move forward if there is such an institution as an international ombudsperson for children.
I found that interesting because we'd been discussing one of the conventions that sometimes works, the Hague Convention on the civil aspects of international child abduction, because I'm sure, as the audience may be aware, the statistics on the incurrence or the recurrence of abductions is on the rise, and it's really frightening. With, we have intercultural marriages, people travel, the world is shrunken, and all of that. And I noticed that within the convention, with which I have some familiarity, there's no means of appeal against any one nation state if their central authority and their courts have not interpreted the convention according to the universal principles. Could an ombudsman then jump into that situation?
Well, first of all, let's take a look at the implementing and monitoring mechanism that's provided for already in the Convention on the Rights of the Child.
There's the permanent secretary.
No, there is a committee on the rights of the child, a committee of 10 experts that considers the reports of countries. Countries are supposed to come, states parties are to make a report before this committee on how they have implemented the Convention on the Rights of the Child. And they do this within 2 years of their date of ratification. So there is monitoring, and it's a very interesting committee because it does make comments and general observations, and hopefully on the basis of their comments and recommendations, something will be done within the country. The practice that is evolving, because of course this is one of the youngest monitoring bodies, is that cases are actually sent to the committee. And
they are.
Yes, and what is also interesting, and I think this is something that you could use.
This will be news to all of us.
Yes,
none of us knew
that this committee has provided for 2 stages in their considering states parties reports. The first stage, after the country has sent in a report that is supposed to be democratically considered, both government as well as non-governmental sectors. That report is first discussed with non-government entities, including international organizations and UN agencies. Right. And here, individuals and non-governmental organizations can come and say, this report is not accurate.
Right.
So they can consider that. So in a way, there is already a mechanism in the Convention on the Rights of the Child. Then after that, the government comes to make its formal presentation. I think what is needed is to make use of these mechanisms that are there, but it needs people to know what is there.
All right, let me ask you a question, because we're still on this convention. We see all roads seem to lead to Rome here, and I must admit, I put my hope and faith in this convention that ultimately it becomes a very effective tool to administer law in a fair way for the child and from the child's point of view. But this brings me to some correspondence I've recently had with El Presidente. I hope he doesn't mind me referring to him as El Presidente. Bill Clinton has sent me a letter, and one which is incredibly forthright and very interesting, in which he is talking about the UN Convention on the Rights of the Child, and he says he had decided to instruct Ambassador Albright to sign the convention. I think he has.
She did.
It has been signed. But he also says in paragraph 2 of this letter, and this is what attracted my interest, I also want to make it clear that this convention will not serve as a basis for litigation in America's courts. Now, he says they're undergoing a final analysis. They also want to add in reservations and understandings. So now I want to ask both of you in turn what impact the President's view of this accord is going to have on U.S. citizens and U.S. children, U.S. parents. Joe, do you want to kick off?
Based on what I said before, that I think that the accord itself is imperfect and doesn't go much further than what the states already do in the United States, that it probably doesn't make much difference whether the president gets the legislation in order to make that applicable in the United States. And I'm not sure that there's a whole lot.
But there's no federal statute. I mean, however imperfect the convention might be, and we can discuss that, and I'm sure Puri might disagree with you. However imperfect it might be, isn't it better that there is this international convention superimposed upon our national law, which is superior to all federal and state law, while one considers that there is no federal legislation at all?
It would be a good idea to install in the federal courts of the United States the power to deal with these problems. And if they do that by implementing legislation to enact this UN provision, then that's a good step forward.
Yes, I would have thought this provision, no matter what your view of it was, that it sets out very important principles, and I think it's a building block. Would you agree?
The Convention on the Rights of the Child is not just a mere building block.
I didn't mean to imply that that's all it was.
In fact, what it is, as I had always said, is that it is a codification of some basic laws and basic principles that are already there and improve on this. The Convention on the Rights of the Child has a very interesting provision, and it says that should there be higher standards in domestic law, then those higher standards that protect the child will prevail. So I really don't see any difficulty for the United States government that believes that there are superior laws protecting civil and political rights in the United States.
Xenophobia.
I mean, even that, assuming that, then there should be no logical reason why the United States would find difficulty in adopting legally the Convention on the Rights of the Child, which are minimum universal standards.
Exactly.
So I would certainly say that if there are activist judges and courts, if there are creative lawyers, I think that they will be able to find ways within existing laws to incorporate the principles in litigation.
Well, let's ask Joe, who's a lawyer here. Could you argue off this convention, given the president's position that they will not allow this to be, used as a basis for litigation in this country? Could you alternatively say in a court that yes, it does apply, even though it's not self-executing, because it's a part of customary international law and part of the law of nations?
Not successfully.
I always like to run with these arguments.
But on the other hand, I mean, there is precedent in the United States for taking international treaties and turning them into United States law. The international trade field is the classic example. The whole world has to trade with each other, and they've devised a set of rules to govern the trades. The United States implemented legislation to give effect to those international rules, and there are bodies in the United States, agencies in the United States, and courts in the United States that do this, while there are comparable agencies and courts all over the world in all these countries that have agreed to these treaties that are all interpreting the same rules and attempting to find some way of making the rules uniform.
Yeah, well, we don't always interpret them universally. This is one of the problems we find with the Hague Convention, for instance.
But they look to their guidance from the international treaty, and they say this provides the standards, and courts all over the world are attempting to apply that. Absolutely. American courts are applying that just as Japanese courts are applying it. Now, will they always get it exactly the same? Of course not, but they're striving to achieve a uniform interpretation, and so it could certainly be done in this field.
Well, Stuart, I think what would be interesting from the international community point of view is how the United States can come out year after year with a State Department chronicle judging the performance of every country in the world under a scale of 1 to 10, who are the countries that are performing well under international standards. So if they're going to use those international standards as the set of criteria, then why are they not applying it to the United States?
So you're saying there are double standards here?
Well, I don't know. I mean, I'm asking the question actually more than anything. Right. And I think that if one is going to use the measure for other countries, then I think those measures ought to be used for one's own country and one's own performance. And this is what the international community is asking, if the United States is going to maintain a leadership role and maintain a high ground for judging other countries' performance. And I think it should. Then I think that it has to show that it accepts a convention like the Convention on the Rights of the Child, where
it isn't even controversial, really, is it?
Well, there are some articles that may raise some questions and maybe would be subject to reservation. But certainly, when this convention is accepted and ratified or acceded to by all countries except for 6 countries, including the United States, then you say, well,
has the United Kingdom signed this?
Pardon?
Has the United Kingdom signed the convention?
Yes, everyone except the United States, Oman, Somalia, and that's because they don't have a government in place.
One good reason.
United Arab Emirates, Cook Island, and Switzerland. So the United States is in very good company. This is.
Is there some fear? Because this issue has come up in our other programs, where it seems to me the majority of the views proffered by our human rights experts is the consensus view, is that this country refuses, for some odd reason, to accede to these international instruments and to ratify them, giving them the force of law, not only recognition, but the enforcement of them as law in U.S. courts. Let me ask Joe this question. I mean, because I think we're dealing probably with a psychological or a political problem.
It goes back to 1945. This country perceives itself as the saviors of the world. Therefore, why should they adhere to some other nation's standards? Since we have the highest standards imaginable, and we've saved the world, why do we think we can learn anything from any other country?
So is it really just xenophobia?
I think it's a chauvinism, and it's unfortunate, but that's the way it is. It pervades American political life. Every time somebody says, let's let the UN do something, huge numbers of American politicians rise up in arms and oppose it. Because they want the control to rest in the United States. So it's a very important part of the fabric of our society.
Puri, what can we do to alter this? There are many concerned people in the United States who have a great belief and appreciation of human rights. And today we're discussing, as we have on the last program, children's issues, which have never before, to my knowledge, been discussed in this context. But of course, they're part of this large envelope of human rights. And what can we do to educate, to pressurize, to advance the issues so that they're heard by the American public, heard also perhaps by the British public, because I've experienced there, which is very similar to my experience here. Is there anything that can be done?
Well, one is we can clone Stuart Ryan.
Oh no, don't do that.
More of these kind of programs. I think this is very important. If we're going to universalize these standards, then we have to disseminate information. And the 50th anniversary of the United Nations, I think, is a very good event for the Convention on the Rights of the Child. I think everybody should know that this year it marks the 50th anniversary of UNICEF.
It's noted in our titles, but we've never discussed it amongst ourselves.
I think that this is And in 1998, you have the 50th anniversary of the Universal Declaration of Human Rights.
Which is something we have discussed in the first two programs.
Yes, and I think that this is, at least this is one document that has really a universal appeal. Interestingly enough, at least in our jurisdiction, I'm a Filipino, and in our Philippine Supreme Court, the court has cited as a basis of giving rights, cited the Universal Declaration of Human Rights, not the legal documents. So I think this is definitely the Universal Declaration of Human Rights can be considered customary international law, if none of the other instruments are. So I think dissemination of information is one. Since Mrs. Eleanor Roosevelt was the president of the Commission on Human Rights when the Universal Declaration of Human Rights was. Yes, and what is also very interesting is, this is quite personal to me, Mrs. Roosevelt was president in 1948, and I think we should celebrate that. We and the United States people should celebrate that and own the Universal Declaration of Human Rights. And there were, Stuart, that in the 50 years of the Universal Declaration of Human Rights, I hope this will change, there had only been 3 women who had presided over the UN Commission on Human Rights. Every 20 years. Well, Mrs. Roosevelt, yes. The Princess Pahlavi of Iran in 1970, and I had the honor and privilege to preside in the 1990 46th session of the UN Commission on Human Rights. So I hope that this will change. This is not gender bias. In fact, it's gender bias on the other side.
I hope not. Yes. I'm tired of dealing with those issues, and my gosh, we have plenty of those issues on the table. Well, now that we've discussed all of these high-minded principles, I want to return to an issue, return to Joe and an issue in American law, which I think is important to me. And then I want to look at it, having reviewed it in our own national context, to take the international view, again, the UN view of it. The issue I want to raise is this idea that we have 50 states with 50 different sets of custodial or domestic relations law, and whether this can any longer be maintained, or whether it's time for the federal courts to step in and to make one codification.
I think the two things are not necessarily inconsistent. Yes, the states are going to retain a very important role in it, just as they do to this day in education. But on the other hand, I think that it would be a good thing for the federal courts to intervene more than they have been in the past, to attempt to establish some basic standards that are applied by all the states. So I think
but let me raise an issue with you,
because
I can't quite get your drift on this. If I raised an issue such as the state of Texas has recently passed a domestic relations law which makes a presumption in law of joint custody, so that if two parties go to the court, the idea is that the nominal decision will be joint custody. So folks, don't really come here and fight unless you really have a good case against the other parent for doing something so terrible that the child should be separated from the other parent. Now, if we say, and I think that that's a positive step, I think joint custody and presumption, as a presumption in law should follow, but New York State does not. New York State continues with its sole custody to mother decision-making process. The question I now raise is there an issue, a constitutional issue? Is there an issue of equal protection under the law? Under the 14th Amendment.
There is an issue. Now, the next question you want to ask is, what is the likelihood that in the very near future some federal court is going to agree that the Constitution demands that be the law? And I think the answer to that is slight. I think it will be done in small bites. If you go back to the school segregation system, what happened was that they fought that in the courts for roughly 20 years. Right. Little by little by little. They started out with state law schools, and they focused on whether or not state law schools could be discriminatory in who they accepted. And then they slowly and gradually expanded the coverage until in 1954, the big rule came.
Well, let me ask a really stupid question that hadn't occurred to me to ask before. Are children a classification?
I think that children of separated or divorced parents are, compared to all other children. Just like fathers who are non-custodial parents are a class compared to other fathers.
Have any cases ever gone before the courts?
Yes, at least on the father classification. And there is an important case that upheld that classification and said, yes, divorced fathers fighting custody battles are going to be considered a class for purposes of the Constitution.
All right, well, let's make a presumption then, so I now bring Puri in again. If we assume that there is an argument to be made that a father in New York State, where there's no presumption for joint custody, is put at an unequal in an unequal position to a father in Texas, where there is such a presumption, is this parenthetically also possibly a violation of the convention?
Well, the way
any convention.
the way I would look at it, and it goes back to, I think, an important question that you raised, which is that since domestic relations is basically within the jurisdiction of each state in the United States, is there a room for federal standards? And my answer would be, if the Convention on the Rights of the Child were to be ratified or acceded to, then that would be your minimum standard on the federal.
So it would operate much like the Convention on Abduction, which is now ratified as called ICRA.
So that would be your minimum standard. So any state law would have to adhere or harmonize to that minimum standard, and it's the same thing globally. The Convention on the Rights of the Child is the minimum standard for all states. I mean, what happens is that the interpretation, the application, and the elaboration would depend from state to state.
All right, very quickly, because we've got about 1 minute left, let me ask you each very quickly, what is the future for human rights and the child? Puri, you want to just go quickly, 30 seconds.
Very hopeful. I think that the Convention on the Rights of the Child is nearing universal ratification, and certainly it's unprecedented. And I think that the child is is somebody that we need to nurture, because otherwise we have no hope for the world.
Great.
Most men don't even know what the rules are, and when they find out, they're going to realize something has to be done.
Well, I think that pretty much sums it up for the evening. All that remains is to thank my special guests, Joe Sahid and Dr. Puri Quisumbing from the United Nations, to thank you all for being here, and to say good night, Godspeed, and be ever watchful of your rights.